partnership agreement that we have drafted for Jalha Kindergarten. After 8 years of doing his business as sole proprietorship, our client, Mr. Kadri, would like to expand his business by bringing in Riaz as his working partner and also Alin, representing Anak-Anak Cemerlang, as his investor for his business.
To address this concern, we have drafted 5 customized clauses that bridge the gap between Kadri need and the requirement of the LLP Act 2012.
For Section A, Capital Contribution and Profit Sharing. For Section 1, the initial capital of the partnership shall be Kadri, no cash contribution, contributed in the form of existing business assets, which are classroom furniture, playground equipment, and 2 multi-purpose vehicles, MPV. For Riaz, no cash contribution, contributed in form of working experience and skill. While Anak-Anak Cemerlang Sedia Berhad, cash contribution of RM200,000 Malaysia, and social networking for educational sponsorship. For Section 2, profit sharing of each partner shall be as follows: Kadri, 60% of profit gain; Riaz, 10% of profit gain; and Anak-Anak Cemerlang, 30% of profit gain. For Section 3, the initial capital so contributed by each of the partner is credited to the capital account of each partner. The following provision of this Section 8 shall apply in respect of the capital contribution of the partners. The capital fund of the partnership shall belongs to the partners in proportion contributed by each partner. Any further contributions of capital required by the partnership may be contributed to the partnership by any one or all 3 partners without limitation. As to the amount of such further capital contribution and any such additional capital contribution shall be treated in the same manner as the initial capital contribution above set out, and no partner shall be entitled to interest on the amount of its capital contribution to the partnership. For the drafting note of this section, this 60% allocation to Kadri is designed to ensure he retains majority control and voting power as specifically requested, reflecting the high value of his established Jalha Kindergarten brand and physical assets. The agreement legally recognizes his 8 years of sole proprietorship and ensures his dominance in decision making remains proportional to the significant tangible assets he is bringing into the limited liability partnership. Next, the remaining 40% is split to balance financial liquidity with operational expertise, which Anak-Anak Cemerlang receive 30% in exchange for their Ringgit Malaysia 100,000 cash injection and strategic networking. Meanwhile, Riaz is allocated 10% their sweat equity to reward his loyalty and the superior performance of the Seremban branch.
Next, for Section 9, which section for management and voting rights. Subsection 1, the management and control of the LWB shall be structured as follows. Notwithstanding the capital contribution amount, Kadri shall retain 16% of the total voting power on all partnership matters. Anak-Anak Cemerlang Sedia Berhad shall hold 20% and Riaz shall hold 10%. Unless otherwise specified, all decisions related to the ordinary course of business shall be decided by a simple majority of voting power, which is greater than 50%. Extraordinary matters such as the admission of new partners or the sale of significant assets shall require a special resolution of at least 75% of the voting power. Riaz shall be appointed as the compliance officer to manage day-to-day regulatory requirements reporting directly to Kadri. Next, for the drafting note for Section 9, this section specifically addresses Kadri's demand for 60% control, ensuring he can unilaterally pass ordinary resolutions even if the other partners disagree. By separating voting powers from capital contribution, the agreement protects Kadri's leadership while assigning Riaz a formal management role to leverage his proven performance and loyalty. The inclusion of 70% special resolution threshold prevents any single partner from making major decisions unilaterally, which helps mitigate Kadri's general fear of risk and major changes without substantial consensus. This section ensures the extraordinary decisions such as selling significant assets or admitting a new partner require agreement from at least two partners, promoting stability and protecting LLP from undesirable changes.
For Section 10, non-competition and confidentiality, Subsection 1 said all partners shall maintain strict confidentiality regarding the Johor kindergarten, student database, curriculum and teaching method. For Subsection 2, during the term of this LLP and for a period of 1 year thereafter, all partners are prohibited from using the partnership proprietary information to solicit clients or staff for any competing business. Subsection 3, to address the transition from a sole proprietorship to an LLP and manage personal risk, the parties agree as follows. The LLP shall take all necessary steps to undergo a novation of the bus contract with safe right plans to transition the agreement from Kadri's personal name to the name of the LLP. Upon execution of the novation, the LLP shall assume all rights and obligations under bus contract. Next, the LLP agrees to indemnify Kadri against all costs, claims and demands arising from the bus contract and the 20 existing employment contracts, provided such liabilities were incurred in the ordinary course of business. Next, in accordance with the Limited Liability Partnership Act 2012, any debts or obligation incurred by the LLP, which includes bank loans, are solely the liabilities of LLP. Next, no partner shall be personally liable for the LLP debts unless the liability arises from their own wrongful act or omissions. And the last one, the LLP shall indemnify every partner for payments made and personal liabilities incurred by them in the ordinary and proper conduct of the LLP's business or for the preservation of its business or property. For the drafting of this section, this clause directly addresses Kadri's concern regarding the bus contract by mandating novation process to transfer the personal liability from Kadri to the LLP. By providing a back-to-back indemnity, the agreement ensures that even if the transfer takes time, Kadri is financially shielded from personal loss, effectively transitioning his sole proprietorship risk into the proper entity. The next, this note clarifies that the partner's liability for bank debts is limited by the Limited Liability Act 2012, directly answering Kadri's fear of personal bankruptcy over partnership loans. It balances fairness by ensuring that while the LLP assets are first in line to satisfy creditors, no partner is personally burdened by their business financial failure unless they commit a wrongful act, providing the peace of mind Kadri requires to expand the business.
Then for Section 11, which is section for assumption of liabilities and indemnity, this section addresses the transfer for existing liabilities from Kadri's sole proprietorship to the new LLP, particularly concerning the safe right bank contract and potential bank borrowings, while also ensuring all partners are protected from losses incurred during the LLP's normal operation. Subsection 2, the LLP hereby assumes and agrees to be solely responsible for all existing liabilities, debts and obligations related to the Johor kindergarten business as operated by Kadri as a sole proprietorship immediately prior to the execution of this agreement. This assumption explicitly includes but is not limited to the high value contract with safe right band signed by Kadri in his personal name. For subsection 3, the LLP shall indemnify and hold harmless all partners against any all claims, damages, losses and expenses, including legal fees, which incurred by them in the ordinary and proper conduct of the LLP's business, provided that such losses do not result from a partner's gross negligence, willful misconduct or breach of this agreement. For subsection 4, Kadri as the former sole proprietor agrees to indemnify and hold the LLP and other partners harmless from any and all liabilities and obligations arising from the operation of the business prior to the effective date of this LLP agreement, except for those specifically assumed by the LLP under subsection 1. For the drafting notes under this section, this section provides clarity that the LLP, not Kadri personally, will manage and addresses Kadri's anxiety regarding the bus contract liability. The general liability provision protects all parties equally for actions taken in good faith for the LLP's benefit, ensuring fairness to Riaz dan anak kanda Cemerlang Singapura. It protects Kadri by shielding him from personal liability for future debts such as bank loans, as partners in an LLP are generally not liable for LLP's debts. Under Section 12 of this agreement, it provides for employment continuity, which the partners agree that the LLP shall assume the employment of all 20 existing staff members currently employed at the Shah Alam and Seremban branches of Jauhar Kindergarten. Such employment shall be maintained on the existing terms and conditions, ensuring full continuity of service, seniority, and benefits for all of the employees. For the drafting note, this section helps maintain business stability and retains the kindergarten's institutional knowledge by maintaining all 20 staff members from Kadri's sole proprietorship to the LLP. This protects Kadri by reducing the risk of losing staff members or having staff resignation during the transition, which ensures that the loyal employees such as Riaz get to keep their seniority and benefits. This approach helps to preserve the quality of care and education level that the Jauhar Kindergarten branch is known for.
Lastly, for Section 13, Permits and Licenses, throughout Subsection 1 until 3, it stated that the licenses for Jauhar Kindergarten are currently under Kadri's personal name, and after the agreement is signed, Kadri will transfer the licenses or help the LLP apply for new one from the Ministry of Education, the State Education Department, and the relevant local authority, with all related costs paid by the LLP. Until the licenses are officially issued under the LLP name, the LLP might continue operating using Kadri existing licenses where legally allowed without paying any royalty, and will identify Kadri against any fines or penalties. For the drafting note, this section directly addresses Kadri's concern by making clear that he needs to either transfer the existing licenses or apply for the new one. Since the LLP is a separate legal entity, it also protects him by ensuring that the LLP covers all related administrative costs and provide a legal mechanism for the kindergarten to continue operating while the necessary permits are being processed by the authorities.